Mr. Zobrist, are you the only one appearing on behalf of Evergy today?
No, Roger Steiner will be appearing as well. I'll be doing the oral argument.
Okay, I'll wait just a few minutes for Mr. Steiner.
Judge, I was also going to ask Lisa Starkebaum, who is the manager of regulatory affairs, who submitted the affidavit with the FAR filing for the 12th accumulation period, just in case there was a technical question. I don't think we'll be getting into that, but if a commissioner has a technical question, I asked her to be available, but otherwise it's just Mr. Steiner and I who will be appearing.
Okay, thank you. I did not establish an order for parties, and I didn't set any time limitations. Do the parties have a preference as to who goes first, second, and third? And I'll remind everybody that MECG has asked to be excused, and I'm going to grant that on the record shortly.
Judge, this is Nathan Williams for Public Counsel. I do not intend to argue, but I am available should the commission have questions.
Thank you, Mr. Williams.
Judge, since
staff is happy to conform to whatever order you would prefer, Judge.
Okay, Evergy, would you like to argue first or second?
yeah, we think it's appropriate for Evergy to go first. We were the submitting party as far as the tariffs, so we're more in the position of being the applicant or the entity requesting action by the commission. So I think we should go first. I'd like to have just a couple of minutes, if necessary, to as the moving party to offer any rebuttal.
Any objection to that?
No objection, Judge.
Thank you, Mr. Thompson.
Okay, I will go on the record at 9. Let's bring this proceeding to order and go on the record. Good morning. Today is February 18th, 2022, and the current time is 9 a.m. The Commission has set aside this time for oral arguments on whether Evergy Missouri Metro can exclude extraordinary revenues from Winter Storm Uri from its FAC, and the matter captioned as, in the matter of the application of Evergy Missouri Metro, Inc., doing business as Evergy Missouri Metro for authority to implement rate adjustments required by 20 CSR 4240-20.090, parentheses 8, and the company's approved fuel and purchased power cost recovery mechanism. and this is file number ER-2022-0025. My name is John Clark, and I am the regulatory law judge presiding over these oral arguments today. On February 10th, the Commission issued an order setting oral arguments in this matter. The parties have previously filed a stipulation of facts and briefs for the Commission's consideration. The Commission's staff requested oral arguments, and the Commission granted that request. Oral arguments are being held both in person in room 310 of the Governor Office Building, as well as via WebEx, telephone, and video conference. At this time, I'm going to ask the parties to enter their appearance for the record, starting with Evergy, Missouri Metro.
Thank you, Judge. Carl Zobrist on behalf of Evergy from the Denton's US LLP firm, 4520 Main Street, Suite 1100, Kansas City, Missouri, 64111. And with me is Roger W. Steiner, Corporate Counsel at Evergy, Inc., period, 1200 Main Street, 16th floor, Kansas City, Missouri, 64105. And I'll be presenting the argument, Judge.
Okay, thank you, Mr. Zobrist. On behalf of the staff of the Commission.
Thank you, Judge. Kevin Thompson for the Commission staff, P.O. Box 360, Jefferson City, Missouri, 65102.
Thank you. Mr. Williams, would you like to enter your appearance even though you're not arguing?
Sure. Nathan Williams, Chief Deputy Public Counsel, appearing on behalf of the Office of the Public Counsel and the public. My address is P.O. Box 2230, Jefferson City, Missouri, 65102.
Thank you, Mr. Williams. And finally, Midwest Energy Consumers Group filed a motion to be excused from this hearing, and I'm going to grant that motion. So Midwest Energy Consumers Group is excused. Now, the parties have agreed to an order of oral arguments, with Evergy going first, then the staff of the Commission, followed by a rebuttal by Evergy. Is that correct?
Your Honor, that's correct. Your Honor, this is Roger Steiner. Could I interrupt for a second? We have a couple of people that aren't arguing that are involved with the FAC that would like to view this, but they're having trouble signing in. Could I ask that we wait a moment until we can get them in this proceeding?
That will be fine. I will wait until you give me a signal.
Okay. Let me see what's going on.
And Judge, as I said before we went on the record, Lisa Starkebaum, who is a manager of regulatory affairs at Evergy, who presented the affidavits and testimony when this current matter was submitted as the 12th accumulation period filing. She's also available if there are any technical questions. They may not come up because this is, we think, purely a legal issue, but she is available if the Commission has any questions.
Thank you, Mr. Zorbers.
In that regard, Judge, if I may, I have Brooke Mastrodonis and also Kim Boland from the Commission's technical staff with me.
Thank you, Mr. Thompson.
So our people are saying that the WebEx invite keeps asking for a password but doesn't accept the one in the email.
Okay, there was a change in the initial password because I found it long and confusing. If they are not using the 0025 password, they're using the wrong password.
Is that the whole password, or does it just start with 0025?
That is the whole password.
0025. Okay, I'll tell them that.
0025.
0025. Thank you.
Roger, you might be able to forward your email that you used to access too, if you did so.
Well, that's what I did. So I'm finding it strange because I'm on here. So I don't know. I'm going to tell them to use that password.
We're going to go off the record for the moment. Mr. Steiner, were your additional people able to join?
We're getting mixed results, Judge. Ron Clote is able to join by phone, but there's two other people that wanted to hear the oral argument. And Lisa Starkeybaum is on by phone. So let me see about one more.
Judge, this is Jackie. I can send direct invites if I need to as well.
Thank you, Jackie. We'll see if we need that.
And we also have Shelley Jordan on the phone. I'm just waiting on one more person.
Okay, I believe all your people are here.
I was waiting for Darren Ives.
Okay, that's one more.
I lost track.
Okay, now I believe all your people are here.
All right. I see Darren Ives. So thank you for your patience, Judge.
We'll go back on the record. I'm going to remind everybody to silence your cell phone if you're here in person. If you're attending by phone or WebEx, I'm going to ask that you mute yourself. If you're attending by phone and you need to unmute yourself for whatever reason, you can use *6 to do so. Do the parties have any preliminary matters that the commission needs to take up this time? Evergy?
We do not, Judge.
Staff?
No, Judge, thank you.
Okay, hearing none, we'll move on now to the oral arguments by the parties. The attorney for each party will be called to come forward and speak to the commission with any questions to follow, or possibly commissioners are welcome to interrupt me if they have a question as well, or interrupt the speaker. With me from the commission today are Commission Chairman Ryan Silvey and Commissioner Holzman. I don't know if we have any other commissioners on at this point, but others may be joining us. With that in mind, Evergy, if you would like to start, give me just a second to let everybody know you're going to be. All right, go ahead.
Thank you, Judge. This is Carl Zobrist representing Evergy, Missouri Metro, Inc. May it please the commission. Here we are on the 1-year anniversary of Winter Storm Uri, dealing with the extraordinary events, both in terms of costs and revenues from a year ago. And although at least here in Kansas City, we had an 8-inch snowfall that was quite challenging, we did not experience the extraordinary events that we're still dealing with Winter Storm Uri. Our position remains the same as it was in the briefs, that both extraordinary costs and extraordinary revenues caused by Winter Storm Uri should be excluded from this FAC proceeding under paragraph 11, that's Roman numeral 11 of section 8 A, 2.A of the Commission's Fuel Adjustment Clause rule. This would be consistent with the Fuel Adjustment Clause statute, section 386.266.1, which recognizes that both increases and decreases in a utility's prudently incurred fuel and purchase power costs should be dealt with in that mechanism. Similarly, all the definitions in the rule deal with both cost increases, cost decreases, and revenues. And the specific scenarios, as we noted in our brief in paragraph 11, deal with increases and decreases in costs, which would therefore include revenues. And more importantly, this would be consistent with the action that you took when Evergy Missouri West, Metro's affiliate public utility, filed its FAC case, where both the costs and the revenues were excluded from the FAC and not passed through. It shouldn't matter whether the extraordinary costs were incurred, as by Missouri West, or where extraordinary revenues were received, as in the case of Metro. Under both circumstances, the 95-5 sharing mechanism is not appropriate, where the intent was to avoid rate shock and volatility in rates. These excluded items, we believe, should be addressed in the AAO case, the Accounting Authority Order case that we filed, number EU-2022-0025, which we filed at the end of June of last year. A factual record can there be developed. Ultimately, the final issues would be decided in the pending rate case of both Evergy Metro, the applicant in this case, as well as Evergy Missouri West. There too, in the rate cases, you can address the jurisdictional allocation methodology issues that affect Metro because it does business both in Missouri and Kansas, and we have different methodologies there. I would note before I go further that the amount of Metro's revenue from Winter Storm Uri has decreased from last summer. The amount of the customer net benefit of $31.5 million that was noted in this case, in the 12th accumulation period case, has declined to about $26 million as a result of Southwest Power Pool resettlements. And they may change further because resettlements, according to the advice that SPP has provided to its members, including the Evergy companies, will include additional resettlements for the month of February, which should be received sometime very early March, at the end of this March of 2022. So these new Metro figures, which were filed a little more than 2 weeks ago with the Commission in the current 13th accumulation period, not this one, should be dealt with as we propose them to be dealt with in the 12th accumulation period. And giving this continuing SPP resettlement process, this is all the more reason to treat the Metro FAC filings just like you treated the Evergy Missouri West FAC filings. If you follow staff's recommendation, you would be acting inconsistently with your orders in the West case, where you acknowledge that the extraordinary costs caused by Winter Storm Uri should be excluded under the Fuel Adjustment Clause. You would be saying that costs that result from an unusual event and an infrequent occurrence should be treated differently from revenues that are caused by the same event, which is extraordinary in both cases. And you would also allow the 95-5 sharing mechanism to be applied on a one-way basis under circumstances that are not related to the incentive purpose there. So we think the best way to resolve these issues is to treat this case the same way that you treated the Evergy Missouri West FAC case, by excluding the extraordinary costs and revenues from the FAC under paragraph 11. Again, a factual record can be created for both Metro and Missouri West in the Accounting Authority Order case. The costs and revenues would be deferred into either a regulatory asset or liability. Jurisdictional allocations can be dealt with there. Mr. Clote has a proposal there, ultimately to be dealt with in the rate cases. and it would also avoid the fuel adjustment clause 95.5 sharing mechanism. So because additionally, the changes in the figures in our most recent fuel adjustment clause filing, just filed a couple of weeks ago, create the same issues that we have in greater amounts of money. In this case, the 12th accumulation period, we think the best thing for the commission to do is to exclude those costs and those revenues from both the pending FAC case here, as well as the 13th accumulation period that we filed just a couple of weeks ago. Thank you, Your Honor.
Thank you, Mr. Zobrist. Any questions from the commission? I hear none. I have one question that comes to mind. If these, and we've chosen to call them extraordinary revenues, are allowed to flow through the FAC, how is the company harmed?
Well, it's really not a question of harm, Judge. We think that it's not permitted by the rule. I mean, the rule says that extraordinary costs may be excluded. You already did this in the Evergy Missouri West case. We think it's inappropriate here under these circumstances to apply that 95.5% mechanism. We think all of these costs should be deferred so that they can be treated similarly because they're extraordinary costs. So we think there's an inconsistency here. Actually, if anything, there could be a benefit because of this 5% that you have to flow to the utility, but we don't think that's appropriate in this case. This is an extraordinary event, and it ought to be treated for all utilities, whether we're dealing with costs in the case of Evergy Missouri West, or we're dealing with revenues in the case of Evergy Metro.
Thank you. Now you said may when you were talking. You also indicated that it was not fair or appropriate. You also indicated that you don't believe it's allowed to go through the FAC. Can you expound on that at all?
Well, Judge, all we're saying is because this is an extraordinary event, and the commission has traditionally, for decades, treated extraordinary events differently from just the slight fluctuations we see in the fuel adjustment clause. We don't think the fuel adjustment clause was intended to deal with this kind of a situation.
And I understand you think it's not appropriate. If you'll remember, my question was, how is the company harmed? And that's a different question from, is it appropriate? Is the company harmed?
Well, I really don't know if the company is harmed, but what we see is if you begin to treat customers in different utilities in the same state differently, that creates harms for both the customer and the company. For example, I mean, if we have cost issues rather than revenue issues, they should be treated the same.
Okay, thank you. Any other questions for Mr. Zobrist? I hear none. If you'll give me just a second. Okay, staff, would you like to make your argument?
Thank you, Judge. May it please the commission.
And would you be sure your microphone is on and that you're speaking directly into it? We had some issues with that last time.
Absolutely, Judge. I don't have anything to control whether or not the microphone's on up here. Unlike the others, it doesn't have a button. Is it on?
As far as I know.
I will speak directly into it and as loudly as I can. Will be sad when I go home.
This is Nathan Williams. We had troubles with the connection on that microphone in the past. If you want to hear him better, you're probably better off at council table.
Are you okay giving your argument from council table?
I certainly am, Judge. Whatever is most convenient for me.
I just want to be sure everybody can hear you. Go ahead, Mr. Thompson.
Thank you, Judge. May it please the Commission. We are here because Evergy, Missouri Metro has improperly refused to distribute to ratepayers some $30 million in net off-system sales revenues. Last July, Evergy, Missouri Metro proposed a tariff to adjust its charges related to the company's commission-approved fuel adjustment clause, referred to as an FAC, intended to take effect on October 1, 2021. However, it did not take effect because staff recommended that the tariff be rejected, and the Commission accordingly did reject it. Staff recommended that the tariff be rejected because Metro refused to include the net off-system sales revenues in the calculation, although the tariff requires the inclusion of those revenues. The FAC is a rate adjustment mechanism, or RAM, authorized by Section 386-266, pursuant to which Metro's rates are adjusted every 6 months between general rate cases to reflect fluctuations in its fuel costs. Fuel costs are the largest single category of costs for an electric utility. These fuel costs are offset by certain types of revenue, chief among which is off-system sales revenue. Section 386-266 authorizes the Commission to build an incentive into the FAC to encourage the company to keep its fuel costs as low as possible, and the Commission has done so. Metro's FAC tariff provides that only 95% of its fuel costs will be recovered from its customers. Likewise, only 95% of any off-system sales revenue is credited to the ratepayers to reduce the amount of fuel costs they must pay. That leaves that 5% that Mr. Zobrist referred to that is due to go to the company under the FAC tariff. Staff advised the Commission to reject the proposed tariff because Metro had withheld from its FAC the windfall net revenues realized during an unusual event in February 2021 known as Winter Storm Uri. This storm, which lasted from February 13 through February 17, 2021, particularly affected the southern Midwest, freezing natural gas wellheads in Oklahoma and thereby obstructing the supply of gas, causing widespread power outages in Texas, and causing energy prices to skyrocket right here in Missouri. As a result, Metro's off-system sales revenue skyrocketed and significantly exceeded its fuel costs, resulting in some $30 million of net Missouri jurisdictional revenues, 95 of which should be distributed to ratepayers through Metro's FAC. This case is one of a cluster of related cases, some of which were referred to by Mr. Zobrist. There is case ER-2022-0025, the Winter Storm Uri AAO, or Accounting Authority Order case. Metro and its affiliate West both seek to defer extraordinary costs and revenues related to Winter Storm Uri rather than immediately process them through their FACs as those tariffs require. The status of this case is that it has been stalled since October 26. This case is ER-2022-0025, Metro's FAC rate adjustment tariff. Metro submitted a FAC tariff, as I explained earlier, excluding the quite significant Winter Storm Uri net off-system sales revenue, 95% of which is owed to the ratepayers. There is also case ER-2022-0129, Metro's now pending general rate case. It was filed in January of this year. Metro included no proposed treatment of the Winter Storm Uri costs and revenues in that case, although they occurred during its proposed test year. Metro seeks approximately $47 million in increased revenues in that case, even though it is improperly holding hostage over $30 million belonging to the ratepayers from the Winter Storm Uri net off-system sales revenues. Finally, there is case ER-2022-0026, Metro's current FAC rate adjustment tariff, filed January 31st of this year. Staff's recommendation is due on March 2nd. Metro has again submitted an FAC tariff adjustment that excludes the lion's share of the Winter Storm Uri net off-system sales revenue that it owes to its ratepayers. I can tell you that staff expects to recommend rejection of that tariff also. What is driving all of these cases? And this was not explained by Mr. Zobrist. Metro operates in both Missouri and Kansas, and so must allocate its costs and revenues between the two states. Because of a mismatch between the demand-based jurisdictional allocation methods used in Missouri and Kansas, Metro asserts that it would be required to distribute 107% of the Winter Storm Uri net revenues to Missouri. 107%, that is more than it actually realized. Metro refuses to do this until the jurisdictional allocation mismatch is corrected. It hopes to accomplish this in its general rate case, ER-2022-0025, by getting both Missouri and Kansas to move to identical hybrid allocation methods. I can tell you, however, that staff will oppose Metro's jurisdictional allocation method change proposed in that rate case. This is a complicated case, and the controlling law is also complicated. The commission, of course, is created by state statute and has no powers other than those specifically granted or necessarily implied by those statutes. In 1979, the Missouri Supreme Court, in the most famous of all Missouri utility-related decisions, advised us that the Commission's powers do not extend to allowing electric utilities to have fuel adjustment clauses. In 2005, however, the Missouri General Assembly enacted Section 386-266, which expressly grants that authority to the Commission. Accordingly, the Commission has promulgated rules to implement Section 386-266, and those rules appear at 20 CSR 4240-20.090. And we have had occasion to refer to those earlier today. Mr. Zobrist referred to Section 8. As you know, an administrative rule duly promulgated within the scope of the applicable statutory rulemaking authority has the force and effect of law. A utility requests an FAC by proposing a tariff describing its operation. This must be done in the context of a general rate case, and the FAC must comply with the Commission's FAC rule and with Section 386-266. I should mention that a tariff duly approved by the Commission and maintained on file for public inspection also has the force and effect of law. It is binding, the courts tell us, on the utility, the utility's customers, and on the Commission itself. This is called the filed tariff doctrine or filed rate doctrine. This is a well-established principle of law. How do these considerations affect the questions before us? First, Metro's FAC tariff does not permit it to withhold the net Winter Storm Uri off-system sales revenues from the FAC. The tariff does not include any exception, nor does it have a provision allowing waiver. The Commission's FAC rule has a waiver provision, but Metro's FAC tariff does not, and the tariff controls. Second, the Commission's FAC rule does not authorize deferrals. At 20 CSR 4240-20.090, parent 8, parent A, 2.A, parent 11, that as provision 11 from now on. In a list of items to be submitted in support of a proposed rate adjustment tariff, the rule refers to, quote, extraordinary costs not to be passed through, if any, due to such costs being an insured loss or subject to reduction due to litigation or for any other reason, end quote. That language, plainly, in and of itself, does not authorize any deferral or any exclusion. What that rule actually says is, A, when an electric utility files with the Commission tariff sheets to change its fuel adjustment rates and serves it upon parties, the filed tariff sheets shall be accompanied by, number 2, the following information in electronic format where available with formulas intact. A, for the period of historical costs which are being used to propose the fuel adjustment rates. 11, extraordinary costs not to be passed through, if any, due to such costs being an insured loss or subject to reduction due to litigation or for any other reason. The rule simply describes one item among several that must be supplied to the Commission in support of a tariff proposing a fuel adjustment clause rate change. It does not authorize anything. And I will point out that neither of those listed circumstances are applicable here. An insured loss should not be distributed because it is no loss at all, since an insurance proceeds are expected to cover it. Costs subject to litigation should not be distributed because they are uncertain as to amount and ownership. The net Winter Storm Uri off-system sales revenues at issue here, by contrast, are certain. They're not subject to litigation in terms of amount or ownership. The ownership, at least, is clear. The amount is evidently continually changing. For any given moment, we can say what the amount is. Third, Section 386-266.6 provides, once such an adjustment mechanism, that is an FAC, is approved by the Commission under this section, it shall remain in effect until such time as the Commission authorizes the modification, extension, or discontinuance of the mechanism in a general rate case or complaint proceeding. The AAO case that I mentioned earlier, where Evergy Metro is seeking authority to defer these revenues, these net revenues, I should say, it is not a general rate case, and it's not a complaint case. Consequently, the Commission is without authority to grant a deferral, an exception from the operation of the FAC in that case. The net Winter Storm Uri off-system sales revenues must therefore be distributed as Metro's FAC tariff requires. Fourth, Section 386-266, as I noted earlier, authorizes the Commission to build an incentive into the FAC to encourage the company to keep its fuel costs as low as possible. And the Commission has done so with Metro's FAC. It provides that only 95% of the fuel costs will be recovered from customers. Likewise, only 95% of any off-system sales revenue is credited to the ratepayers to reduce the amount of fuel costs they must pay. Section 386-266.9 provides, quote, in the event the Commission lawfully approves an incentive or performance-based plan, such plan shall be binding on the Commission for the entire term of the plan, close quote. Under this provision, the Commission lacks power to alter the operation of Metro's incentive plan containing FAC, except in a general rate case when the term of the plan is completed. This is not a general rate case, and the AAO case is not a general rate case. The Commission can only alter the operation of that FAC when the term of the incentive plan has ended. Well, you might say there is a general rate case pending right now. and the commission is free to change Metro's FAC in the context of that case. Well, that's true, but how do you get the net Winter Storm Uri off-system sales revenues into that rate case? Under the terms of the FAC, they are required to have already been distributed. 95% to the ratepayers, 5% to Metro. The commission is expressly prohibited, as I have explained, from altering this incentive plan. And Metro's FAC does not allow for any deferral or exception. Based on these considerations, the unavoidable conclusion is that the commission is without authority to grant an AAO to defer distribution of the net Winter Storm Uri off-system sales revenues. The commission therefore must order Metro to distribute those revenues through its FAC without further delay, including interest at Metro's short-term borrowing rate to make the ratepayers whole for the time that they have had to wait while this money has been improperly withheld. And I will close by saying, if the commission disagrees with me and decides that it has the power to grant this AAO, then staff strongly urges the commission to not do so. These revenues were realized during the test period, the test year of an ongoing rate case. They should be distributed and not further withheld. Thank you very much.
Thank you, Mr. Thompson. Any questions from the commission? I have a question. Let's set aside Evergy's tariff and the filed rate doctrine for just a second, and let's just look at the commission's rule as it sets out there, where it says it sets out extraordinary costs. Why should these revenues not be excluded, given that they don't just come from somewhere else? These revenues are a direct result of Storm Uri.
Correct.
Just like the extraordinary costs that I don't believe the commission is challenging excluding. Why shouldn't this be treated the same way? I mean, other than the fact that it says costs.
Right. There is a disconnect between what staff is arguing here and what staff recommended be approved with respect to the costs that Evergy West wanted to defer. I will acknowledge that, and I don't have an explanation for that, other than the fact that in preparing this case, writing the briefs, and analyzing the applicable law, I came to a different conclusion. The language of the commission's rule, as I did my best to explain, does not authorize any exclusion. It simply says if there are items excluded, then they are among the quantities that must be presented to the commission in support of the proposed tariff. It's simply a list of items, one of which is items excluded. It doesn't use the word deferral, let me mention, anywhere. And we analyzed the two items, the two examples of items excluded, and we saw that both of those were appropriate for exclusion. One, because it's not a loss, it's going to be covered by insurance proceeds, presumably not yet received. And the other one, because litigation makes it uncertain. This situation is not akin to either of those. In this situation, under the normal operation of this utility, admittedly in abnormal conditions, the utility realized off-system sales revenues that significantly exceeded its related costs. That's an unusual circumstance right there. But the FAC tariff and the FAC rule, neither of them says, oh, if the weather is such that you make money rather than spending money for the accumulation period, well, then you have to do something different. Neither of those things say that. And because they don't say that, I don't think treating that revenue, that unexpected windfall revenue differently, I do not believe that is permissible.
Okay, thank you. I got one kind of follow-up based on what you said. You said that costs, that the way it's set up now, there's no, they're excluded, but there's no mention of an AAO, there's no allowance for deferral in the commission's rule in regard to that. Isn't that exactly where it's going for some of the other companies that have applied? And if it's not to go to an AAO, where else would it go?
I think it has to be treated the way the tariff requires. You know, the AAO is a creature of the Uniform System of Accounts. The Uniform System of Accounts, and I believe it's account 185 or 186, allows the utility to treat extraordinary items differently. And because the commission might not agree with what the utility has done, the practice has arisen whereby the utility comes to the commission to get an order, an accounting authority order, authorizing it to give those extraordinary items different treatment. And the thinking about this is that, well, rates are set up based on a normalized year. We go to a lot of effort to normalize the weather and normalize the costs and normalize the revenues in order to predict a pro forma or future year when rates will be in effect and rates will cover costs and leave a little bit extra for profit, which is what the system requires, okay? So what happens? In reality, of course, there's no such thing as a normal year. Every year is out of whack. In every year, rates and costs do not match. Either the customers are paying less than they should, or the company is earning more than it should. Somebody is benefiting from regulatory lag. And regulatory lag just means that costs and revenues have changed, but they're not reflected in rates. So, in that world, extraordinary items are treated under the Uniform System of Accounts, right? They can be deferred to be dealt with later. Because maybe it's a cost from a winter storm, good example, that just isn't reasonable for the company to have to shell out for when it's not collecting rates that were set with such a thing in mind. There's an example. But we're not in that normal world. We're in the world of the FAC. That's a different world. The legislature created the authority to grant these FACs, these RAMs, and in that situation, there are certain strictures placed on the company and on the commission if you choose to go down that FAC road. And I mentioned two of those, right? That the FAC continues in operation until the commission changes it in a general rate case or in a complaint case. That if the commission creates an incentive plan in that FAC, the commission cannot alter it until the term of the incentive plan is completed. That statute specifically states the commission cannot alter it. It's not directed at the company or at the ratepayers. It's directed at the commission. It says, don't touch it. You create it, you're stuck with it. That's the situation we have.
Is it your opinion, or is it staff's opinion, that if the commission orders that these amounts flow through the FAC, that necessarily and logically cuts the commission off from issuing an AAO for these amounts?
Yes.
And is that merely because they've already been distributed?
Yes.
Give me just a second. Okay, I don't have any more questions for you at this time. Are there any follow-up questions based on mine by the commission? I hear none. With that, we will move on to Evergy's rebuttal.
Thank you, Judge. Am I being heard properly here? Oh, clearly?
Yes, I can hear.
Okay, thank you. I
Yeah,
heard
I
a
can
slight
hear you.
echo. Okay, thank you. Well, I appreciate Mr. Thompson's acknowledgement that staff is recommended inconsistent resolutions to both the Metro and the Missouri West case. To call it a disconnect is a diplomatic way. It is absolutely inconsistent. And the consistent way of dealing with this problem would be to apply paragraph 11 as it is written. This is an extraordinary cost. It is an extraordinary revenue. And if you look at the last portion of paragraph 11, it says for any other reason. And if you link that back to the word extraordinary, we're talking about extraordinary costs and extraordinary revenues. We had a situation in Evergy, Missouri West of an extraordinary cost that was excluded from the FAC with staff's approval, recommendation. The commission's order is final. That has been excluded. And that is, in our view, awaiting a disposition in the accounting authority ordered case. That's where it should go. Pardon me. Similarly, in this case, we have an extraordinary revenue, a smaller amount than the cost in Evergy, Missouri West, but still a significant amount. It should be treated in the same way. It should be sent to the AAO case, and there it should be dealt with. And there the commission can begin to deal with the jurisdictional allocation issue too. Judge, you asked about a harm to Evergy Metro. If the FAC were applied in this case, when it wasn't in the Missouri West case, we would be failing to deal with the jurisdictional allocation issue and passing through sums that reflect off-system sales that were not made. So that's a harm to Metro. But finally, I would say what we're trying to do here is to urge the commission to act consistently. The FAC rule was drafted with this paragraph 11 that gave the commission the authority to either reject or affirm the utilities proposal about extraordinary costs or, in our view, revenues that should not be passed through. That was done in the Missouri West case. It should be done in this case. That would be the fair thing to do. The jurisdictional allocation issue can be dealt with in the AAO case, and the methodology issue be dealt with in the rate case. But the commission was not wrong in the Missouri West case. We think it would be wrong because it would be inconsistent in dealing with revenues in this situation. Costs and revenues should be dealt the same. Both issues should be taken up in the AAO case, and ultimately decisions would be made in the rate cases with regard to all of the other issues.
Thank you. One question comes to mind. Why is Evergy asking that these revenues be excluded from the FAC to an AAO and not excluded from the FAC and being dealt with in the currently filed rate case?
Because we need to have a deferral order. And these costs should be excluded, and we believe that they should be deferred because they relate to an extraordinary event. And the commission has historically dealt with extraordinary costs in connection with accounting authority orders. And to the extent that they include extraordinary revenues that would turn into either a regulatory asset or a regulatory liability, the AAO is the proper vehicle for dealing with those. And then ultimately the cost issues can then be dealt with in the rate case.
Thank you. In the company's opinion, if these revenues were excluded from the FAC and an AAO were granted, could that AAO defer those revenues to the currently filed rate case?
Well, we believe there's enough time, given that the rate cases were filed just 5 or 6 weeks ago, that can be dealt with as with appropriate procedural orders in the rate cases.
Okay, I have no further questions. Any questions from the commission?
Judge, this is Commissioner Sylvie.
Go ahead, Chairman.
Thank you, Judge. So I would just like to clarify that last answer. If the commission were to grant the AAO, it could then be disposed of in the current rate case, and the company is not necessarily expecting us to defer it to the following rate case years down the road. Is that correct?
Well, I have to say I've not conferred with my client on that. I'm just thinking that because the rate cases were filed January 6th and we're awaiting a procedural order, that they ought to be able to be dealt with in the pending rate cases consistent with SPP resettlement charges.
Chairman Silly, this is Roger Steiner. I could chime in. It could be dealt with in the rate case or the next FAC case after the AAO decision.
Okay. Thank you. Thank you, Judge.
Thank you, Chairman. Any other commission questions?
No
Hearing
questions,
none.
Judge.
Thank you, Commissioner Holzman. I have no additional questions. With that, Ms. Bench, when are transcripts of
Judge,
this?
This is Nathan
Yes.
Williams for Public Counsel. I know
Go
I
ahead,
said
Mr.
I didn't intend to argue, but I do have a piece of information that the commission might find relevant.
Go ahead.
In addition to, there was a reference to Evergy West and being in a similar posture to this Evergy Metro case. There was an earlier case involving Liberty, dealing with the same type of issue in terms of storm costs and whether or not they should flow through the FAC. The case number for that is ER-2022-0025.
Thank you, Mr. Williams. Okay, Ms. Bench, when will transcripts be available for this proceeding?
My instructions say March 4th.
March 4th, sounds good. Are there any other matters by the parties that need to be addressed by the commission at this time?
Not from Evergy, Judge.
Well, I'd like to thank everyone for their participation today. I understand that the weather did not make it the most conducive to do this morning, so I appreciate everybody participating in these oral arguments. With that, I'm going to adjourn this proceedings, and we will go off the record.
Thank you, Judge.
Thank you, Judge.
Thank you, Judge.
Hey, Judge.